can't hear you, Judge. I can't hear you.
All right, let's try that again. Mr. Huddleston?
Hey, how you doing?
I'm doing well. How do you pronounce your first name?
My name is Stefan.
Stefan, okay.
Yes.
Sir, can I have you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes, sir.
Okay, you can put your hand down now. Would you state your full name for the record?
My name is Stefan DeAndre Huddleston.
And Mr. Huddleston, you filed a petition to change your name. What is it you'd like to change your name to?
I would like to change my name to Christian Diaz.
How did you happen to pick that particular name?
Well, I picked that name because I knew that I had to change my name, but I didn't know what I wanted to change it to. And I was looking at Sports Center, and I wanted a name like the professional baseball players, and that's why I picked that name. And actually, I made it up, and I came up with it from looking at Sports Center.
Were you aware that there was a professional soccer player by that name that played, I believe, for Argentina?
No, I did not know that.
Okay, so you told me why or how you picked that particular name. Can you tell me, please, why you want to change your name?
I want to change my name because I'm from Nashville, Tennessee, right? And the other people that was from my father's side of the family, they never did like me. And they never did like me because I had their last name. And my mother's real last name was Reed. And they never liked me and my mother because we did actually have that last name because we weren't Muslims. Me and my mother were Christians. And for a long time, I went through a lot of discrimination from their side of the family. And finally, I came to the actual conclusion that I had to change my name because of the discrimination that I had went through from their part of the family.
Do you have any remaining contact with that part of your family?
No, I don't, because my mother passed away ever since I've been in prison, and I've been in prison ever since 1999, like 99 or 2000, and my biological father, he was in court when I had my when I was in sentencing court, and he was swearing they never did like me, and they always hated me and stuff, and they swore that I wasn't a Muslim, and they wasn't gonna never take my side and stuff like that. And it was like 20 years ago, he told me that I had to change my name. That was the only way the discrimination was gonna stop from their side. And I'm just now finally getting around to it.
What current discrimination are you experiencing?
Well, I'm actually going through a lot of religious discrimination, and it's kind of bothersome because I mean, I fully want to be a Christian, and I don't want to go through discrimination from other Muslims and stuff because of their side of the family, which is all Muslim. And I was brought up in a Christian household by my mother, but I'm stuck with their last name. And it's making me stuck with their religion just from having their last name.
Well, I've encountered the last name Huddleston before.
Yeah.
That's not a Muslim name.
Well, I mean, it's not a Muslim name, but from the family that's down in Nashville, all of my stepfathers, I mean my biological father's brothers, all of them are claiming Muslims. All of them, even their stepkids and their other offspring, all of them are claiming Muslim. And I can't be a part of it because uh, it's just too much discrimination. I mean, that's the only way that I could say it.
So, Mr. Huddleston, the statute under which you filed your petition,
Yes.
which authorizes me to grant a name change for an adult,
Yes.
Requires that your petition show a sufficient reason and that the change is not sought with a fraudulent intent.
Yes.
And then the statute provides that if the individual who petitions for a name change has a criminal record, which you do,
Yes.
the individual is presumed to be seeking a name change with a fraudulent intent. The burden of proof is on a petitioner who has a criminal record to rebut or overcome the presumption. That's a high standard that you have to, if you were in front of me today
Yes.
without a criminal record, I would probably grant your request. But because the statute puts this heavy burden on you to show that you don't have a fraudulent intent, I have to look very closely at the reasons that you give. And the difficulties I'm having with the reasons you're giving is you're not exposed to this family anymore. You're in prison far away from Tennessee. You have no further contact with that part of your family. It just doesn't square with the reasons you've given me, that it's to avoid discrimination. Because of that, I'm sorry, I'm going to have to deny your request today.
Okay. Okay.
All right, I will issue an order to that effect. Have a good day, sir.
Okay. Thank you, Judge.
Welcome. Okay, Peter, if you could give this to Julie when she comes back. Okay, let's see what's up. Henry Reynolds.
Good morning, Judge. How are you?
I am well, thank you. How are you?
Good.
This is Clark versus Henry Ford Health System et al.
Yes.
And I'm looking, I don't see,
A defense attorney?
well, one whose name is on the pleadings. Let me run some names by you.
All I would know is Michael Stevenson or Troy Clark, possibly.
Michael Stevenson is there. Oh, and I do see him. I'm sorry, I missed that. He was the
Okay.
top one listed.
Okay,
Looks
great.
like that's the, all right, looks like we have a connection. This is Clark versus Henry Ford Health Systems. Ms. Reynolds, on behalf of the plaintiff, and state your appearance, please.
Yes, Carleen Reynolds on behalf of plaintiff Sharon Clark.
And Mr. Stevenson?
Michael Stevenson on behalf of the defendants.
Either of you expecting anyone else this morning?
No.
Okay, so this is plaintiff's motion to compel case evaluation, award facilitation costs, and for third adjournment of trial. Let me put your hearts at ease regarding the adjournment of the trial. I have no idea when I'm going to be doing a jury trial again. I've given up making forecasts of that. So your request for adjournment of trial is granted.
Okay.
And what I'm probably going to do is not set a new trial date until I know when I can start doing jury trials again, so we don't have to keep going through this exercise of scheduling and rescheduling. It's just extra work for everyone. So what I'll do is schedule a status conference. We'll find a date that works for you. My secretary will get a hold of you to find that date.
Okay.
I did read the motion and the response. I am not inclined to award facilitation costs.
Okay.
The fact that somebody comes to facilitation and doesn't want to facilitate, other than here's my offer, take it or leave it, I can force you to go to facilitation. I can't force you to make any kind of a concession while you're there. I can't do that to either side. But what I can do and will do is order case evaluation. Case evaluation is mandatory for medical malpractice cases. There's no way around it. The statute is, or the court rules vary. The statute's clear and the court rules clear. I cannot. Now, parties frequently choose to facilitate instead of case evaluate. And if that's successful, who cares that you didn't do case evaluation? I'm not worried about that. But in cases where an attempt is made at facilitation and it has failed, if either side asks me for case eval, I'm going to order case eval. Like I said, I don't have discretion to deny it.
Okay.
So we do case evaluation every other month here in Jackson County. I think it's the even month. I'm not sure of that. Obviously, I haven't been involved in case evaluation in a number of years, so I honestly just don't remember. How soon would you be ready to submit the case to case evaluation?
No.
Yeah.
So Judge, I would have, to me, there's two options. Either we could go through case evaluation, or Mr. Riley actually read both of our briefs that we submit, our summaries that we submitted. And he actually, spent the time to go through them all. And he's willing to assign a number, but he couldn't do that without a court order, even though I had it in my notes that I'd written down that was supposed to be what was done originally. But he just couldn't do it without a court order. So he's already done all the background and he's familiar with medical malpractice. I'm fine with him assigning a number or going through case evaluation, whichever
Mr. Stevens, what's your
If-
feeling on a
If Mr. Riley's,
designated?
if Mr. Riley's was the equivalent of a non-unanimous award, then I would be okay with that. Otherwise, then we need to go through a 3 panel so we can see if they will do a non-unanimous award. Because we don't want to, we're going to, telling you now, we're going to reject, so we don't want to be bound by sanctions if possible. So,
And obviously, that's exactly why I want it, because liability is all but admitted in this case. So yeah, that's exactly why I want it.
Great. I can certainly let parties stipulate to have a single case evaluation award. If you don't stipulate, I don't believe I have authority to order it. Case evaluation process is spelled out pretty clearly in the court rules. You have to
Okay.
follow that process. So what I will do is I will order your case submitted to the next available case evaluation date. You're probably, well, I'm not sure when they're doing it this month, but my guess is you're probably too late. Uh, uh, The next date then would be a date in April, if I'm correct, that it's on the
Okay.
even months. What I will do is I will direct my civil secretary to find out when the next available date is that we can get you in with sufficient time to get briefs submitted. If that's possible yet in February, I'll order it in February. I don't know what day in February they're doing it, so I'll have to find that out. If it's too short a time to do it in February, then the next date will be whatever date they're doing them in April. We'll
Okay.
figure that out and we'll let you know.
All right. Because we'd be ready to, I mean, I would be ready to submit a summary today if we needed to. So,
very good.
Okay, let me see what I can find out. Have
All
a
right,
good day,
so-
council.
well, Judge, so as far as an order goes, are you going to draft an order?
I'll take care of an order. I'm
Okay.
just simply going to do a removal of the trial date, scheduling of a status conference. Once I find out what the case evaluation accept reject deadline is, I'll schedule a status conference for after that.
Okay.
And we'll just keep kicking the can down the road in terms of status conferences until I know for sure when I can schedule the trial.
Sounds
I want
great.
you to have a date that you can count on rather than, who knows? Okay,
I know you don't like to predict, but if you had a wild guess, are we talking trials in 2021 in the fall or 2022 or any wild guess?
I sure hope by the fall of this year, we should be past all of this. I think if by then enough people will have been either had COVID or been vaccinated against it, we'll probably reach that herd immunity that we don't need to do lockdowns anymore. As soon as they stop doing lockdowns, we're going to start doing jury trials, but that's the problem.
Perfect. All right.
Thank
Thank you,
you.
Judge.
Sorry, I can't be more helpful than that. Have a good day.
Thank you.
too.
Okay. Put this in Patty's box, please. Okay, let's see. Lingers. Okay, looks like we have an audio connection with everyone. Good morning. This is Fifth Third versus Med Service et al. Melissa Lengers for the plaintiff, Kevin Thompson for defendant Brent Askins. And Mr. Thompson, this is your motion to set aside the default. I've read the motion. Ms. Lengers, if oh, I see. There is a response. Hold on a minute.
Morning, Melissa.
Good morning.
Nice to meet you.
Nice to meet you too.
Thank you.
I like these Zoom hearings, especially on this snow day.
Yes,
Very
it would
convenient.
have. I-94 would have been a long drive for you this morning.
Yes, it would have. So I say we keep Zoom hearings forever.
I don't know what the judge's opinion is on that, but I can see that happening. I kind of like the social aspect of being in the courtroom and talking to everybody, but
True.
I'm not sure what's going to happen that way.
Yeah.
My intention is, once we're past COVID, is to offer this opportunity to anyone who would prefer not to make the drive. It works fine for me.
Nice.
I understand why local attorneys who are already in the building would prefer to attend in person, but if you're coming from a distance, I plan to make this available.
Well, I think the Zoom hearings make me look fatter than I actually am, so I'm coming in person.
I think they have programs that actually allow you to alter your appearance.
They're called diet.
Is there filters on Zoom?
I'm sure somebody's worked on something like that.
Yeah, I've seen that. There are altering things you can do, I guess.
Well, let him focus reading my response. Stop distracting him.
That was you're wise to me. You already know. You're already wise to me.
It's a good one.
Okay, well, the thing that caught my attention most was the Exhibit C, affidavit of non-service. So I had read, Mr. Thompson, your client's affidavit indicating that he wasn't at his residence address and therefore didn't get the notice. But this affidavit of non-service indicates an unsuccessful attempt on July 21st at 201 West Shore Drive in Jerome. That is Mr. Brent Askins' personal residence?
It is, Judge, yes.
And no answer. Heard individuals talking, white F-250 parked in the drive along with a maroon Jaguar, both vehicles registered to the defendant. I'm sympathetic to the argument that he wasn't at this residence and therefore posting at this residence didn't alert him to the fact that he was being sued. But this certainly would indicate that he was at the residence, Mr. Thompson.
Well, Judge, in terms of what happened before August 6th, I haven't discussed that with Mr. Askins, but the fact is, one attempt was there's a belief or a supposition that he's attempting to duck service. I just don't think is valid. I mean, normally we have a situation where people come in to set aside the default after collection efforts have commenced. Mr. Askins, as soon as he was aware of this action, and that was on the December 21st mailing that he got on January 5th, came to me right away, Judge, and said, I know nothing about this. I thought this was all resolved. His father, who was Dr. Askins in town, he and his father did run a medical or a walk-in clinic, or a couple walk-in clinics in the Detroit area. He's a businessman, Judge, that doesn't duck his responsibilities. And so I don't know what happened in this July, or who was present or who didn't answer the door. I don't know anything about that. All Mr. Askins desires is his opportunity, for to mount a defense under this personal guarantee action that's been filed. And, obviously, we don't doubt that he posted that there was a posting. Ms. Lingers has, provided the photograph. But this is just one of those situations. And although I didn't, cite rule MCR 2.612, there's a justification here for the opportunity to litigate this issue. Obviously, I'll be involved on behalf of Mr. Askins, and his affidavit clearly indicates he had no idea of this action whatsoever until he received the default judgment on January 5th, Judge.
Ms. Lingers?
Yes, Your Honor. The defendant's motion and affidavit does state August 6th through August 9th, the defendant was not present at the location. So our affidavit of non-service was prior to that. That was just to show that our belief is because co-defendant, his father, was personally served with the lawsuit prior to him passing away, unfortunately. So I think it's safe to assume that his father told him, hey, I was just served, you're named in this lawsuit as well. And then when we tried to make our attempts on Brent Askins, he was evading service and then conveniently left the area and country. But we've provided proof he was served pursuant to the terms of the order for alternate service. When he returned October 10th, he should have had that tacking, and knowledge. But I will rely on the court's discretion here. The defendant has not provided any documentation to provide he was released of liability on this guarantee. So we definitely are prepared to defend if needed, but.
All right, thank you, counsel. Well, I am somewhat skeptical of Mr. Askins' whether or not he was actually aware of a pending lawsuit, but because of a very strong policy that cases be resolved on the merits, I think a sufficient showing has been made of a lack of actual notice and of a meritorious defense. And I'm going to grant the motion and set aside the default and the it was a default judgment as well, was it not?
It
Yes,
was.
All right, I'll set aside both. How soon can you have an answer in, Mr. Thompson?
Judge, I'll have it filed by the end of next week. I'll provide Ms. Lingers. I've been serving her by email. I don't know what's going on with our mail service now. It's just horrendous. But we've agreed that email has been working well for us, Judge.
I am contemplating, I just haven't gotten around to it, modifying my case scheduling orders to provide that whether you stipulate or not, you must serve electronically in addition to actual filing. It's just a whole lot easier. I can't order you to live by electronic. That can only be done by stipulation, but I can order you to do it electronically in addition to regular mail or service. And as soon as I get around to it, I'm going to put that in my standard scheduling order. I think that's just good practice.
I agree, Judge. I agree.
Can't count on the mail. So, Mr. Thompson, if you could submit an order granting the relief requested and provide in it that your answer must be filed no later than 14 days from today's date.
Judge, I'll do that. I'll submit that under the 7-day rule then, or do you want to do that by stipulation, Judge? I'm sorry.
That's up to you.
All right. Melissa, I'll do it. I'll send you the order under the 7-day rule. If you're fine with it, you can sign it and then we can go from there. I can always take a copy over to the courthouse.
Okay.
All right.
Okay.
Thank you, Judge.
Council, have a good day.
Thank you.
Melissa, nice to meet you.
Nice to meet you too.
Thank you as well. I'll get that documentation to you as well.
Okay, thank you.
Thank you. Bye now.
Bye-bye.
Have a good day.
You too. Thank you.
So it doesn't look like. Bless you. Anyone's here on the safe harbor matter again? Do we know what happened?
I don't think we ever looked into it since last week.
Well, but it got renoticed for this week. Did we get anything today saying where these folks are? I haven't looked down on my email yet, so did you see anything?
I don't think I've gotten anything. Let me double check here. But
All right, well, in any event, I've got, let's see who these folks are. Looks like everyone left is on the Bournemouth matter. And then Mr. Schlechty's on that, Mr. Bournemouth. And then I got a couple other names that I don't recognize.
yeah, I've got nothing from Safe Harbor.
Ms. Forbush, so the only name I don't recognize is Derek Warner. Oh, it says case number 22355. Which one is that?
The Gear-Hanson, which they,
Let me get him in.
they dismissed their motion.
All right, well, let me get him in and we'll address that. Oh, the file isn't even here.
I took it out with.
Morning, Your Honor.
Good morning. You are here on the Gear-Hanson versus Henderson matter?
Yeah, it's not my motion. I just wanted to make sure I had appeared, but yes.
We got an indication that the motion was being withdrawn or rescheduled. Did they
Okay.
not tell you that?
No, no worries though. I just figured I'd introduce myself anyway, but no worries at all.
Well, if you had had to drive through a snowstorm to get here, I'd probably compensate you for that, but
Yeah,
a reason to be thankful for Zoom hearings, I guess.
very true.
I'm
Well,
sorry, Shannon, it's Mr. Derek Warner. Which party do you represent, sir?
Progressive with Randy Davis's office.
Well, the only thing, I don't have the file in front of me. It says Gear-Hanson versus Henderson. There may be more parties involved. So is
Yeah.
your client a defendant?
They are. Yeah, it's for Miss Hanson's first party claim. I'm with Progressive for that.
Oh, I got you.
Yeah.
He represents Progressive. All right. You're all set, sir. Have a good day.
You too. Nice to meet you. Have a good one.
Good meeting you. Okay, and next up is the matter of Bournemouth versus City of Jackson et al. And as soon as I have everyone present, we'll move forward. Mr. Bormuth is present. You can hear me, sir?
I'm not on. Hold on.
All right, I can hear you now. Can you hear me?
Yes, now I can hear you, Your Honor.
Okay.
Oops.
Plaintiff, Mr. Peter Bormuth is present. Ms. Audrey Forbush, attorney for defendants, Mr. William Schlechte, co-counsel for defendant Laura Schlechte.
Judge, I also have Mrs. Schlechte, my most important client in 49 years of practice, present in the courtroom with us.
All right, did you catch that, Shannon? That's it. Okay. Mr. Bormuth, this is your motion to compel. I have read your motion and I have read the response. I frankly agree with the response that your requests are grossly overbroad, far beyond what is reasonably likely to lead to discoverable or admissible information, and would be an extremely arduous task to require the defendants to produce everything that you've requested. It just is way, way over the top. When you submit requests of this magnitude to parties in a lawsuit, you require their attorneys to expend a significant amount of effort on their behalf. I generally favor broad, wide discovery, but it's got to be reasonable. And the time frame that you requested and the scope, just in my estimation, don't strike me as reasonably likely to lead to admissible information. So knowing that's where I'm coming from, I do want to give you a chance to convince me otherwise. So go ahead.
Your Honor, I believe that there's a strong likelihood that emails or communications could be found between, say, Derek Dobies and Lee Hampton, where Lee Hampton says, we can't have Peter, he doesn't believe in God. So I don't think that the request either there.
Let me stop you on that. I have no problem ordering them to provide emails or messages among these parties, particular Mayor Dobies and the gentleman that you mentioned, that refer to you. I have no problem with that. I'm assuming, based upon what I've already read, that they've already provided you with any communications that identify you or refer to you.
Now, that's not true, Your Honor. They provided me with my own emails that I sent to Laura Schlechte and to Karen Bunnell. And those are emails I already had.
Mr. Bormuth, let me stop you.
Yep.
Ms. Forbush, have you, I mean, obviously, if there weren't any emails between any of the recipients or senders that he's identified, you couldn't have produced them. Did you at least look for them to see if there were any?
Yes, Your Honor. And in fact, what we did do, I recently went through the voluminous emails that my clients had already provided me, and there were a couple that I had not produced, and I supplemented those responses on Friday, which were emails that were actually, they were initiated by Mr. Bormuth to Ms. Schlechte about Ms. Bunnell. And then there was a little exchange between Ms. Bunnell and Ms. Schlechte. So I've produced those, And of course, they incorporated the emails from Mr. Bormuth. But anytime there's been an email specifically referencing Mr. Bormuth and religion and the Fifth Ward, other than those couple from Bunal and Schlechte, which I have produced, they're all from Mr. Bormuth. They're emails that he has and that he initiated.
I could.
Your Honor, I just point out that.
Hold on. I'll give you a chance. Clearly, any communications among the various defendants and parties and that refer to Mr. Bormuth should be produced. And if you've produced all of those, I want some kind of affirmation that all such communications have in fact been produced. I mean, I get the problem. Mr. Bormuth's requests were so broad that I understand why you filed the objection that you did. But clearly within his request, if there are texts or emails or other communications that refer to Mr. Bormuth, they absolutely should be produced.
Well, Your Honor, I guess my concern here is how far back do we have to go? Some of his requests ask for back to 2016. And frankly, Mr. Bormuth has been involved in a lot of issues before the city council. I mean, can we limit the subject matter for which we are searching, the search parameters that we need to put in to do that kind of search? I mean, Mr. Bormuth emails a lot of public officials frequently. His name will come up, I'm sure, because he's initiated those communications. But if we're narrowing it down to just communications between Doby, Schlechte, and Robinson, the three named defendants that specifically reference Mr. Bormuth related to the Fifth Ward vacancy, I can see that as being very relevant. But, you know, other emails going back to when Mr. Bormuth had a campaign about pesticides on grave sites and things like that years ago, that's a vast search.
I don't believe.
Go ahead.
Your Honor, what I'm most interested in that period of time, and if they wish to restrict it a bit, but you understand that the first time that the vacancy occurred in the Fifth Ward after Andrew Fraunfelker was forced to resign. So this entire process goes back a ways, which is why I ask for the length of time. I'm willing to shorten that, but I would like to see any communications between Arlene Robinson and Lee Hampton and Daniel Mahoney that mentioned my name, and I would like to see any communications between Mayor Dobies and those same parties, as well as Darius Williams, those three that mentioned my name. Let's restrict it to that.
Well, hold on just a minute. I see someone else logged into my waiting room. I just want to make sure it's not someone who's on your case. They didn't identify themselves. So I'm going to let that person in so I can identify who they are. I'm assuming you guys aren't expecting anyone else.
I was not.
It might be the city attorney, Your Honor.
Okay, let me see who it is.
It's not the city attorney.
Well, I'm going to find out who it is as soon as we have an audio connection. Good morning. You're logged in under an iPad name. What is your name, sir? No, you don't have a connection yet. Do any of you recognize this gentleman?
I didn't hear his name.
He didn't say it. I just was wondering if he he hasn't made a connection yet. He hasn't heard me, and he hasn't been able to speak. I just want to find out who he is. So when I put him back in the waiting room, I know who to bring back in for which hearing. All right, looks like we might have a connection. Sir, what is your name? Can you hear me? Sir, on the iPad, what is your name? All right, I'm not going to worry about him. I'm putting him back in the waiting room. He needs to figure out his technology. Okay, I'm sorry. Go ahead, Mr. Borman.
So I'm willing to restrict my requests to emails between Arlene Robinson and Mayor Doby's, Daniel Mahoney, Lee Hampton, and Darius Williams that mention my name. So we can restrict the ones that mention, you know, Martin Luther King Center and the Economic Development Zone and those things that you have suggested are overly broad. The same with Mayor Doby's. I would like all emails, text messages between him, Lee Hampton, Daniel Mahoney, Darius Williams that mention my name. I think that's appropriate, you know, because those people play a background role in the city politics, in the first ward particular, and in possibly in filling the fifth ward vacancy. So I think those are reasonable requests that are not overly broad.
Well, hold on, let me make sure. So you'll forgive me, I don't live in the city, so I don't pay a lot of attention to who our city councilmen are. Who is Arlene Robinson?
She is the council person for the first ward and a defendant in the case.
I know who Mayor Doby's is. Daniel Mahoney is a council person?
No, he is a county commissioner, but he has been active in city politics as well. He led the, he's also the head of the NAACP. He took over for Arlene Robinson, who was formerly president, and he led the petition to change Francis Street to Martin Luther King Boulevard.
And Darius Williams?
He is also a county commissioner. He is, and also he is Arlene Robinson's, the defendant Robinson. He is her pastor at her church.
Your Honor, with all due respect, we are getting far.
Hold on. I just want to figure out who everyone is. And last person you mentioned was Lee Hampton. I know who he is.
Okay. He's the power.
Okay. So were Daniel Mahoney or Darius Williams involved in any way with the appointment of the council person whose seat we were seeking?
Possibly. Possibly.
What based on what? Speculation?
Your Honor, I mean, based on the fact that I had courted Daniel Mahoney and Lee Hampton extensively to support my campaign for the 64th state representative seat. And Daniel Mahoney came out and just blatantly told me that he could not support me because I don't believe in God and I don't believe in Jesus Christ. So, Daniel Mahoney, it's possible, very possible, likely even maybe that people that Mayor Dobies or Arlene Robinson communicated with him about the 5th Ward seat. Same with Lee Hampton. I don't think that's a stretch at all. I mean, you're talking about why a completely unqualified person would get appointed rather than me. And I'm looking in this area for answers because previously there was, a clear statement of religious differences being the reason why I could not get support from the Black community.
And that statement came from whom?
Daniel Mahoney. And Lee Hampton echoed that too. So
Lee Hampton echoed that to you. He told you that you couldn't get supported by the Black community because of your religion.
Lee said essentially that Peter, has, that I say a lot of things that are negative about Christianity, and that's an issue for him. So I have no idea how much influence he has with Derek Dobies. I think it's considerable, and I'd like any emails or text messages that mention my name that are about the 5th Ward appointment. That's a completely limited. It doesn't require a whole lot of searching. I don't think that's excessive.
Your Honor, the fact that a variety of individuals who are not city officials did not support Mr. Bormuth for a position unrelated to city council, whatever position he was running for that he did not get elected to, has nothing to do with this case. And even his own motion says, well, I believe it might produce admissible evidence. That's not enough. That's sheer speculation. Mr. Bormuth wonders why he didn't get appointed to the position. Even in his own documents that he submitted for this motion, he admits in his own writing, I certainly can be a bully. And that has been the prevalent response we've gotten in all of the depositions, is that Mr. Bormuth was a bully. It had nothing to do with his religion. With respect to the motion to compel, we have produced all of Arlene Robinson's emails with regard to the 5th Ward vacancy that she possessed. Mr. Bormuth wants to go well beyond their scope of their positions as city council members and ask her to produce.
Let me interrupt. So when did the 5th Ward opening occur? What was the date?
It became open in 2017.
2017.
And it became open because Mr. Fraunfelker.
He was charged with a domestic violence issue and resigned.
So he resigned.
Yes.
And I'm assuming whatever that date is forward would be a reasonable time period to limit whatever requests are. And we could talk about what the requests are, but clearly it couldn't have been any sooner than when that position opened, that there could have been any
but actually
about who was going to be his replacement. Couldn't be any earlier than that.
It could not be any earlier. And Your Honor, Mr. Bormuth's lawsuit is not about the initial appointment of Kelsey Heck. He is specifically complaining about his application for the vacancy that was filled in May of 2020.
But I did raise that point in my complaint about Kelsey Heck and other appointments that also show that I'm being deliberately excluded from appointments that I'm qualified for.
Did you seek appointment to that opening in 2017?
Oh, yes, I did, Your Honor. That's when Derek tried to push Charles Keeling, someone no one had ever heard of before, through to the seat and couldn't get enough votes. And so then they reopened it. And that's when he appointed Kelsey Heck, who was at that time the girlfriend, now the wife of his best friend and colleague. So, I mean, the entire appointment process at the city has been incredible.
Are we still talking about the first ward?
Fifth Ward seat. Kelsey Heck was the first person appointed to fill it. She then resigned after a recall in order that there wouldn't be an election to fill the seat. And then the city appointed it, had another appointment. And in this case, it was Karen Bunnell who was appointed to fill the seat.
All right. Well, Ms. Forbush, if Mr. Bormuth was seeking appointment back in whenever the process opened up for consideration of applicants back in 2017, I think that's fair game.
Are we limiting this, Your Honor, to text or emails between the three defendants? Certainly, Ms. Robinson's emails related to the NAACP, her capacity as a member of the NAACP, or communications with members of her church are not in her official capacity as a city council member. They invade her personal privacy. I mean, are far beyond the scope of this case.
If they talk about Mr. Bormuth, they should be produced. But I agree, it should be limited to the party. The communications with Daniel Mahoney and Darius Williams are too far removed. I'm not going to order any of those communications.
Your Honor,
I am going to order communications between the named defendants and anyone for that matter that specifically mentioned Mr. Bormuth.
as long as it's anyone, I'm happy.
Well, but I guess I don't understand. I thought you just said anything related to Darius Williams and Dan Mahoney was too far afield. Now you're saying anyone?
No, I believe if those communications mention me, they have to be produced.
Not Mr. Mahoney and not Mr. Williams, but
What?
communication with the other named defendants and anyone for that matter. I don't care who they're communicating with. If they're communicating with someone after the time period where Mr. Bormuth sought appointment in 2017, and they mention Mr. Bormuth, since they would be decision makers, I think those are fair game. And I don't care who they're communicating with. If they're communicating with anybody, a named defendant is communicating with anybody, and it refers to Mr. Bormuth, those should be produced.
So, Your Honor, just to clarify, if a named defendant is communicating with Daniel Mahoney and that communication mentions me, it should be produced.
Yes.
Only in that case, if it mentions me.
I'm not allowing any communications with Daniel Mahoney or Darius Williams. I don't care who the communication's with. If the named defendants are communicating with someone about or referring to Mr. Bormuth anytime from when he first sought appointment to the vacancy created by Mr. Felker's resignation, I think that's fair game.
Thank you.
So they're going to need to search through whatever they've got available to them. I realize that sometimes going back as far as he's requesting is challenging. I don't know how far back I could actually go in my personal email. I mean, I try to keep stuff cleaned out and deleted so I don't have a full box, but who knows? But if they're available, they need to make a reasonable search. If it refers to Mr. Bournemouth after the time period that he sought the 2017, the opening created in Mr. Felker's resignation, is there some target date that we can look at for when Mr. Bournemouth first sought appointment to that vacancy? I'm assuming Mr. Bournemouth, there was some formal communication from you that would be that trigger date.
Yes, I believe the city should still have it. There was an application for the 5th Ward vacancy. And also, Your Honor, may I ask?
Wait, you may wait. So from the date of his application forward, whatever that is, I'm assuming you've got that on record?
And that was,
I'm looking at Mr. Bournemouth's lawsuit that he filed. And he indicates that on August 6, 2018, the city council held a special meeting to fill the 5th ward. Candidates were plaintiff Susan Murdy and Charles Keeling. So I think if we can go from that vacancy.
yeah, but that was the date of the meeting. The communications before that would have occurred when people had just applied before the.
Well,
before
according to your lawsuit, Mr. Felker did not resign until June 12th, 2018.
Okay, well, it's 2018 and not 17. Well, that's fine. We go back to that date.
So Ms. Forbush, when someone seeks appointment to a vacancy, they are required to file an application?
I'm sorry, I did not hear you, Your Honor. I apologize.
Yeah, let me try that again. When an individual is seeking appointment to a vacancy, they are required to file a formal application?
Yes.
And the city maintains copies of those applications?
I would assume they have to keep it for a period of time. I can't represent to you how long they keep those.
If you can find his application, or if you can't, if he still has a copy and can identify it himself, that'll be the trigger date when he filed his application. You don't have to produce anything before that date. And all you have to produce after that date are communications from between the named defendants and anyone else that identifies Mr. Bournemouth by name.
And just
could I ask?
You're saying between anyone else. We don't have to produce the ones that are from Mr. Bournemouth. He emails everybody all the time. I assume he has his own emails.
You don't want your own emails back, do you, Mr. Bournemouth?
No, yeah, and that's what they've produced so far in this case is my own emails.
Well, because those were responsive to your request is why they produced it. During discovery, you don't produce just the things that you've got. You also produce what you got from the opposing party. It just proves when the communication was received, etc. So, of course, that's why you but in terms of communications with others, so the trigger date is when he submitted his application. From that date forward, communications to or from named defendants identifying Mr. Bournemouth by name. And I realize there's work involved in looking for those things. I get that, but I think those are reasonable and could possibly lead to discoverable information. I think Mr. Bournemouth's theory is you don't want me in there because I'm a pagan. I don't believe in Christianity. And that's the real reason you didn't consider me for this position. If that's true, it states a claim. So he's certainly able to ask for communications that discuss him. And if there aren't any communications critical of his faith, then that will simply undermine his claim. but I think it's reasonable to produce those things. Mr. Bormuth, I know you wanted to add something. Go ahead.
I was wondering if they would also be required to produce emails, not just that mention me, but that also mention the Fifth Ward vacancy. I didn't know if that was included in your decision here.
I believe we've done that, Your Honor.
All right. So if you could just verify that you produced everything, any communications with those individuals relating to the Fifth Ward vacancy, but also whether they refer to the vacancy or not, if they refer to Mr. Bormuth, I think they need to be produced.
Understood.
Thank you, Your Honor.
Okay, thank you all.
Judge, what's the time in which those have to be produced? There's a, Ms. Forbush has a motion. Ms. Forbush has a motion for summary disposition set for St. Patty's Day. His response is due 9 days before if he's going to mail it in. So can Audrey, what's the time to produce those things?
If you want to keep your hearing dates that you've scheduled, you need to get these to him at least 7 days before his response is due. And Mr. Bormuth, if once you get it, if you need additional time and they won't grant you additional time, you can file a motion to have me consider that. I don't want you to be crunched. I'm assuming there's probably not a vast number of emails. It should be pretty manageable. But if once you get them, if the volume is such, or if for any reason you believe you need additional time to respond to their motion and they won't grant you that, you can ask me to grant you that.
Thank you, Your Honor.
That work?
Thank you, Your Honor.
All right.
Thank you, Judge.
Thank you all.
Nice to see you this morning.
Have a great day.
Good morning, Mr. Schroeder.
Good morning, Your Honor.
Do you recognize the other gentleman that's there? Keith?
I don't know plaintiff's counsel, Your Honor.
Oh, okay. He's been having trouble with his technology. I tried to get him in earlier. I have no idea who he is. He obviously can't hear me and I can't hear him.
Got to put up a sign.
I may at some point, if I have a phone number, I can just call him, but he's struggling.
Let's see.
According to the little message I've got at the bottom of his window, it said he's making an audio connection. Sir, can you hear me now? I think he's got his audio settings turned off.
I'll have my assistant call him. Hold on. Danny, can you call plaintiff's counsel? He's on Zoom, but no one can hear it. So can you call him? I'm having my assistant call. And now I can't hear you, Your Honor.
I wasn't talking.
Okay.
I was just trying to figure out if this is Mr. Osborne or the Mr. Boncher.
Let's see. Osborne, I don't know what his P number is. Mr. Boncher's has a low P number, so.
So this is likely to be Mr. Boncher.
Yes, Your Honor.
I do have a phone number here. Your office is trying to call him?
Yes. I was just thinking the other well, there was another gentleman I saw just quickly, that might be Mr. Osborne, if he was on this case.
No, I've got somebody logged in with a phone number. Let's see who that is. I just let someone in with a phone number ending in 0815. What is your name?
Hi, hello, Your Honor. This is Attorney Fred Boncher, and I'm having a hard time connecting, and I hope you can hear me.
I can now. So now we know who you are. I can hear you with the telephone connection, so that works. My guess is you've got some of the audio settings turned off on your iPad.
That's what I'm trying to find, Your Honor.
Well, they normally show up if you look in the lower left-hand corner of your screen in the Zoom window. Do you see where there's a mute? You see where there's a mute button and an arrow next to it?
Look, I can't hear you.
Do you see at the bottom of your Zoom screen?
Yeah.
A mute button.
How do you help me get? I can't get my audio in. Oh, shoot.
You'll have to move your mouse so that it pops up.
Yeah, iPads don't have mice.
Your arrow or whatever.
That's the plural. Mr. Buncher, I can hear you on the phone. Can you get the phone closer to your mouth so that I can hear you better?
Let me try it on the phone.
Mr. Buncher, I can hear you over the phone. That works for me. Can you hear me?
Can you hear me better, Your Honor, now?
Yeah, great. Thank you. So I got Mr. Schroeder here, Mr. Fred Boncher. I normally do these off the record, but because I'm in the courtroom handling other matters, we'll just do it here. I did get a proposed case management and scheduling order. This is something you've seen, Mr. Schroeder?
Yes, Your Honor, I received it yesterday.
Boncher, B-O-N-C-H-E-R.
That's correct, Your Honor.
I'm spelling it for my clerk. She needs to make an entry. Okay, Mr. Schroeder, did you get this proposed scheduling order?
Yes, Your Honor. And counsel and I discussed the dates and came up with the dates that were presented.
Oh, okay. Is there a jury demand in this file?
No, I don't believe so.
I'm
All right,
say yes, but let me double check. Yes, there is a jury demand, Your Honor.
Oh.
Okay, well, that'll help in determining when we actually will set a date. I'm hoping by the fall, I will be able to do jury trials. So we'll plug in dates for the dates that are to be set by the court, and we will issue a final case management and scheduling order for you. Anything else I can help you with today?
I just scheduled a trial September 28th, I believe, that the last week, just to let you know.
It should be after that.
Okay.
I guess it'll probably be an October trial date at the earliest.
Yeah, I don't think we need any help from the court. Mr. Schroeder and I seem to get along quite well.
All right, he's just checking his schedule.
I have a trial currently set the week of October 11th.
How long do you expect that trial to last?
Probably at least 2 days.
All right,
But everything else is open.
I'll say no later than, or no earlier than November 1st. How's that?
Okay.
All right, thank you, gentlemen.
Thank you, Your
Have a
Honor.
good day.
Thank you, Your Honor. Sorry with the mix-up.
Problem.
Gotta love technology.
Yeah. Right, Keith.
Okay, have a good day.
Yeah, you too.
Yeah, you too.
Well, I'm sure he wasn't going to be able to figure out how to remove himself. All right, and let's see, what else do we got? Motion for entry of default. Let's bring them in. Not sure who the phone number is. Okay, next up on my schedule is, actually, it looks like I'm a little bit ahead of time here. Deutsche Bank versus Hall. Counsel, state your appearance, please.
Good morning, Your Honor. Charlotte Hack on behalf of the plaintiff, Deutsche Bank National Trust Company.
H-A-A-C-K?
That's correct.
All right, and I've got a telephone number ending in 0532. What is your name?
Anthony Hall.
All right, let me name this. And file. This goes to Patty. This file. Yep. Okay. So this is your motion for entry of default judgment as to Anthony Hall. Mr. Hall, you've not filed any opposition to the motion for entry of default judgment. Do you oppose it?
To be frank, when I got the paperwork, I did not quite understand it. It sounded to me that it was as they were trying to get the title to the house. I actually have some of my marital records. I went through to try to find the title for them and was unfortunately did not find it.
Are you still claiming an interest in this property, sir?
No, sir.
And Ms. Hack, your client is simply seeking to clear title to remove any interest of record that Mr. Hall might have in the property?
That's correct, Your Honor. Because we can't get a copy of the certificate of title, which I believe Allison Hall wasn't able to locate either. Because of that, what we're trying to do is just get a certificate of title issued by the Secretary of State to my client so that they can cancel title. The manufactured home is affixed to the property, but in order to take care of the paperwork required to get that of public record, we need to file an affidavit of a fixture. And so what we're seeking is simply the order basically that indicates that the Secretary of State can issue title in the bank's name, in the plaintiff's name, and that we can proceed with canceling the title to the mobile home at that point. We're just unable to cancel it because at this point it's still in the Hall's name.
All right, well, clearly Mr. Hall is disclaiming any interest, so I'm going to grant your relief. Did you submit a proposed judgment with your motion?
I did, Your Honor.
Let me see if I can find it.
I don't mean to interrupt, sir, but I would swear very early on in our property ownership that they had us turn our title in because they were going to do what they're asking to do now. So I'm thinking that that is why Allison Hall can't find it, and neither can I, is because I would swear when we did our refinance that they had us surrender that title. I don't know if that makes any difference.
It really doesn't. If in fact that happened and they lost it, they still need to be able to figure out a way around it. This judgment gives them.
I totally understand, sir.
All right, I did find a order granting. Let me review it quickly. The order appears appropriate. I'm going to grant it. Mr. Hall, I do appreciate you appearing and explaining your position in this. I think this will simply accomplish what you all intended to accomplish at some time in the past. So I'm going to grant this order. You will be provided with a copy of it.
Thank you, Your Honor.
Thank you. Have a good day, everyone.
Thank you, Your
Be
Honor.
safe.